Yeah, take it away.
And group and today, Josh Carr. So we have a bit of an unusual situation. I am a owner over at the Land Group and an attorney. I've been in real estate practice for 20 years. And Josh and I recently started another firm called the Estate Firm, where we do probate work, wills, trusts, any needs that are kind of fall under the estate umbrella. And so we are
Recording in progress.
worked together for the last 6 months on the estate firm, but we actually have worked together for about 3 years now. So we've known each other, we've worked together on different cases, and he's been a great colleague to me and very helpful even on real estate related transactions. So I thought it would be a great partnership today to come on, for us both to come on today and talk about divorce.
Yeah,
It's a great topic.
as Karen said, Josh Hart, I had a solo practice in Frankfurt. Took on a partner there several years ago, and it's a pretty wide variety of things that I practice in that practice, and including a fair amount of real estate related disputes, typically when it turns into a dispute in the real estate context. Got a few more stories here and there over the years to tell, but some of which have to do with divorce, do not. So anyway, I think Karen's gonna talk about some initial points first, and I may weigh in time to time along the way, and then I'll talk specifically about the divorce and even how marital rights attach, which is related, but not quite in point.
So another one of the main reasons I did want to bring Josh on today is because he actually does divorce. And so I do not do these. I have no experience other than being a divorced person, with that area. So I think it's good to have the full spectrum of insight for you guys. I know I just wanted to briefly to kick things off by touching on the main things that you need to look for and ask and inquire about when you know, particularly when you know it's your listing and your sellers are going through a divorce. So just kind of some quick off the bat things. And if you've worked with me before, you know that I'm willing to, even if it's like a listing and we're not ultimately doing the closing on it, I can pull deeds, I can pull liens, I can pull anything that you need that would be helpful and to get you completely prepared. So I'm always willing to share my cell phone and my contact information. Maybe we can do that at the end or something. But these would be the first thing. Yeah. So I don't know if I normally do that on Brittany. Do you and get a copy of the deed? No, not always. Okay. So if you do know you have a divorce situation, go ahead and get a copy of the deed. Let's see what it looks like, because you don't know if it's just one or the other on the deed, and you want to just be able to get your hands on that and see who holds title, because it might make a difference. And then questions. These can be so awkward, having those conversations. This is probably already a tense situation. They're selling, they're getting divorced. You don't want to ruffle feathers. You don't want to upset them. But, you kind of need to know whether or not the divorce has been filed, and a lot of times they're going to see that as private information. So, but trying to inquire, where are we? Are they just separated and they've not filed yet? In which case, they're still legally married and we're going to list them at closing as married, or has the divorce been filed and it's ongoing in the middle of the process on it? Or alternatively, it could be that they are completely divorced. So you kind of want to have an idea of where they are in the process without asking too many questions. One way maybe to get out of that and, see if, Josh agrees with this, is you might even ask, for one of the divorce attorney's names. If they're not comfortable talking about it, maybe at least you can get some additional information. And again, I'm happy to step in and I can always call the divorce attorney and see where are we in the process, what is the situation, and maybe explain if this has been sticky, I just need to know from a title perspective where they are in the situation. The parties are uncomfortable with sharing a lot of information. So, and I don't, would you have anything to add to that as far as initial information?
Yeah, I would just weigh in on that and just add to what Karen said, that it's important that when you sign that listing agreement, you're agreeing, publishing to the world that you are selling this patch of dirt or this house or this piece of real estate. You're advertising that you are going to be able to deliver good title to that property. And, that gets to be a problem when it turns out that the title is a little stickier than your client being the person who is the only one who holds title. So there's an ex-spouse that maybe doesn't have a right that they would be able to win in court, but they haven't actually signed the quitclaim deed over, even if they're required to. Nobody's enforced that, so they haven't actually inked it yet. Or maybe someone else holds title, and Karen and I recently worked on a case where someone had listed a property for sale, and it turns out that it wasn't held the way they thought. And in fact, their children all were title holders. And so we had to go back and it delayed the sale. And of course, when you do that, it often delays it to where you miss the closing date, which causes all kinds of problems. It causes potential litigation, questions as to whether time is of the essence. And it just is an issue that often can be gotten out way ahead of, as long as you know that the listing client, the client that says, I'm selling this property, or the clients, plural, that they cumulatively, collectively, actually have good title to that real estate.
Yes. Maria from our team is in the office today, and she actually had an extremely unusual situation. If you've worked with our team before in our office, that Maria is the agent contact for all things that the agents need. And she had a situation where the divorce was final and both parties were remarried. So that presents even another layer of issues, right? Because, in Kentucky, if you're going to go sell a property, you need your spouse to sign off on it. And both parties, divorce was final, no quitclaim deed was ever done to put it in one of the other's names. And then we had to get, it was a bit awkward, and believe it or not, all parties came to the closing. So husband and wife, and then new wife, new husband, and all signed together like one big happy family. Actually worked out just fine. So whatever works, but you do want to do a little bit of due diligence there. And again, a little bit of prep work and making sure, whatever title attorney you work with, whether it's myself or one of the other, great ones that we have here in Lexington or in the surrounding areas, is, helping you a little bit in those scenarios. And I just wanted to briefly touch on, anytime you have any scenario, any tricky situation, which is going to be divorce, estate, bankruptcy, foreclosure, or any sort of lien, whether it be HOA, delinquent taxes, judgment lien, or anything like that. So anytime you have any of those 5 scenarios, make sure that you do some prep work on your title. Like, go ahead, contact who you're normally used to working with, ask them if they can sort of do a pre-search, what are we looking at here? And oftentimes, if you've worked with divorce clients before, some of that stuff is not known. Wife might have a judgment lien that husband doesn't know about. And that then is going to attach to the property, and it's then going to have to be resolved at closing. And he may not even know about that, or vice versa, however that works out. So knowing those things in advance and equipping yourself with, lots of good information, while you're listing and while you're doing that pre-work is always a good rule of thumb.
Yeah, just to echo that again, that other person that may have that judgment lien, incurred some debt that is going to somehow encumber the sale, they likely do not have the same incentive to close on the transaction as your client does. And so they're going to be at least a little less eager, or maybe not reluctant. It's just not a priority for them. And so getting them to negotiate, pay that lien, or otherwise deal with it in a way that you can pass good title, it's just, again, can likely cause delays in the whole sale process, which creates a domino effect, because then if you do miss your closing date, then it can cause problems for the buyers. Even if a buyer is in fact wanting to continue to close on the sale, maybe they lose their rate lock, and then, they lose other issues with their financing, and maybe they're no longer able to purchase for a number of reasons. So it just is a number of dominoes that can get really nasty really quickly. And that's, again, when a lot of times I get involved, that so very much of the time can be avoided just by making sure that you have a full set of information relative to that title at the threshold of the transaction, knowing who holds title, who can pass good title, are there any problems with liens or otherwise. It's good to know that well earlier as opposed to, 5 days before closing.
So I think, as you're probably getting the idea, a lot of these are a just case by case basis. What are we looking at? And even like, is it amicable? Like, are they, agreeing, with each other? Are they on the same page? Are you going to have any trouble getting your offers accepted? Is that going to be a problem? And then even up to, going through the closing process and up to the actual closing, do we need separate closing times? Do we need separate conference rooms? Those types of things that you're going to want to be looking at and forward thinking on that, right? Because, this is a very tricky situation that you guys are navigating and almost, representing both parties and trying to navigate their differing interests at times. At the same time, and trying to do that and then come out, looking golden, and being as smooth as possible. So those are very difficult situations to try to navigate, and just know we're here to help you and look at each case by case basis. So for that, so that's a bit of an introduction for you guys on the divorce scenario in general. Now we get into more specific on, what you're looking at. So I'll just kind of kick things off and then kick it to Josh. So when a person holds title, when a person holds title as an individual, so they're the only one on the deed, say they took title as a married person or even took title as a single person. And then later, while holding title and owning that property, they got married or they were still married. And then at some point they get divorced, and then that person ends up as a single person. And then they go and list the property, and then they go and sell. At that point, whether or not they took the property as a married person or a single person, they were the only person on the deed. And our office, we're not going to inquire on anything else as long as that seller is now a single person and he was the only one on title, and he is now going to sell, he or she is now going to sell. So my point being is, if during the marriage that spouse was making some contribution to the property, paying the mortgage payments, paying the property taxes, whatever it might be, you need to make sure that that person gets on deed somehow, because it's not going to protect their interests, and we're not going to inquire once the divorce is final. In our terms, from a title perspective, that dower and curtsy right is extinguished, and we're going to move on. We're going to let that person sell the property, and we're going to give that person a check for 100% of the proceeds. So if you've got a client that's somehow contributing towards property, but their name is not on the deed, or if you, have a friend or you yourself, are in a similar situation, you always want to make sure that, your name gets added to that deed. A little, one example of something that you may or may not know. I have had,
Sorry, I have a question on that. So let's say the spouse that is now divorced that never got on title, you sell the property, do they still have right to any of those proceeds later?
no.
Or they're just,
So once that divorce is final and it's listed as a single person, that's extinguished. Any
Okay.
dower or curtsy interest, which is given to them by common law, that is extinguished. Now, if they should have an equitable interest because they made payments towards the property, that's where, that needs to be known. Somebody needs to speak up, either by getting themselves on the deed, prior to it ever being listed or sold, Or speaking up, if they know it's for sale, that's when you do want to have, you want to encourage them to speak up. They would have to prove that they somehow contributed, they put down the down payment, they've been making the mortgage payments, they've paid their taxes, whatever it may be. They have to prove not that they contributed to household stuff, but specifically to the property itself.
Yeah, and I'll amend that a little bit and just say that a lot of it's going to depend upon if they're divorced at that time, presumably they will have entered into a property settlement agreement or there's a final decree that deals with property. And the terms of that PSA are going to control, but they are going to control as between the parties themselves. In other words, third parties like a title company or someone else, it's not, the land group or some other title company's job to go and peruse the PSA and see who has what title. So in other words, even though they may have a contractual obligation that party A sell the property, liquidate it, and then transfer $50,000 of the equity to party B, that's between them. And any enforcement is going to be done in the family court and completely outside of everybody else.
So it's not going to prevent the close on it,
Correct.
because then they would.
And it could not potentially cloud the title later had the other spouse not been aware of the sale. Later and come around and be like, oh.
It could. So I have seen, we have one scenario, it was probably about 5 years ago, where, and this is in my mind, where it was done a little bit backwards. It should have been done vice versa. So husband and wife get divorced. Originally, both of them were on title when they bought the property. Both of them were on title. They are going through the divorce proceedings. In the middle of the divorce proceedings, wife signs a quitclaim deed over to the husband, and the attorney files it, and he files the quitclaim deed. Divorce is then final, but then wife comes back and says, well, he did not pay pursuant to the property settlement agreement, even though she signed the deed already, which really you shouldn't sign the quitclaim deed until you pay it out. Right. But she had already signed and he didn't actually pay. So then she came back and filed a lien. And then, yes, and in that scenario, that's where you do want to make sure, if you've got the buyers on that situation, you make sure you have title insurance. Because that's where title insurance would step in and cover the buyer who has no idea, doesn't,
Right.
So,
Yeah.
Wow. I'm trying to think, okay, other specific scenarios. I mean, a lot of the divorce cases we have seen lately is they are getting to closing where we have both of the spouses sign at closing. So we've not seen a ton where we have quitclaim deeds just prior to closing, but we do see that where we have quitclaim deeds just prior to closing, and then the other spouse, divorce is final and that person has been paid out. A lot of times, majority of the time, they need to sell the property in order for the spouse to get paid out. So majority of the time we see both parties come to closing, and we do structure a situation where it's, as easy as possible, different times, coming in at different, sometimes even different days, to make that as easy as possible. Typically, we will, inquire or get a copy of the PSA to find out how proceeds are to be split. Often there's times, obviously like the mortgage needs to be paid, everything related to the property needs to be paid. We had a case yesterday where property settlement agreement, which was from like last September, asked for a Victoria's Secret card for like $315, and then one other credit card to be paid upon the sale of the house. And then from our perspective, on our side, we can't, on the seller side, we can't put anything, any payee on there unless it's related to the property, so we can't just add, you see it on the buyer side, because sometimes underwriting requires certain credit cards to be paid for them to take on the new loan. So we can't do that, but on the seller side, we don't get into, what's the credit card balance, and paying that. So in that scenario,
This is not my way to finance your money, Ray. I think that's what I'm getting.
Just tell them,
Yeah. Well, so one suggestion I had made, and we often get this, is that, and I had said that we could do this, is to send the money to one of the attorneys. One or the other, we can send all of the proceeds, to one or the other. They can ensure that any items that do need to be paid, and often I think they like that because they can make sure any fees are arrested.
Yeah. We feel like.
Make sure your bills
I don't think I've ever financed paper lingerie that I've.
But he ended up in that scenario, they did not end up going to the attorneys. It was a 50-50 split after the other items with the mortgage were paid. I think there was a foundation issue that we added that ways to it. And there's a 50-50 split from there. What ended up happening is the husband ended up writing checks, and then I guess he provided copies of those checks to the wife, which seemed to appease her. And so yeah. I was like, well, I can imagine you probably made payments on that since September. I was like, this is like $316 to make sure we secret. The property sale agreement was done like back in October. Maybe it didn't sit on the market for a little bit. So yeah. Sometimes you'll see PSAs where they ask for, one or the other to be reimbursed for making the payments, from the time that the other spouse left. So they get reimbursed for making those payments and recoup that. We don't typically like to do the math on it. I know Tammy Carr had a very difficult situation where she was kind of navigating that. It ended up complicated math figures. There was several things that had to be accounted for on both sides. So we did ask and requested that the attorney work that out, come to some sort of agreement, and then let us know, because at the end of the day, I mean, as you guys know, we want our CDs and our final statements to be final. We don't want anybody coming back after closing saying it should have been this, should have been that. And it to be clear on, on what's what. So, yeah. Examples that I have off the top of my head. Thoughts.
Yeah, I was also going to tack on, I guess, something to a couple of topics, a couple of areas that are not maybe exactly on point as to how divorce directly affects the title to real estate, but something that I think should be under the radar. And that is specifically, okay, what happens after the divorce is filed? So first of all, after the divorce is filed, one of the things that either party should be insisting upon is prompt delivery and execution of the paperwork, specifically those quitclaim deeds, any type of other transfers of assets, whatever that is. It's important that the paperwork be done, because if the paperwork isn't done promptly, and then say one of those newly divorced spouses is disabled or passes away, then you've just got more complications later on down where we've got to find someone who has the authority to execute the quitclaim deed, and it's just a problem. So promptly doing the paperwork is important once the divorce is done. Another scenario that can pop up, of course, is that real estate may not, in fact, be held by either of the parties directly in their own name. In other words, it may be held by a joint revocable trust. And if it is held, it's owned by that trust, then the terms of the trust are going to control as to who the beneficiaries are. Presumably, it is a revocable trust, and between the two of them, they can revoke that trust and transfer title out of the trust into either one of their names or both names, or to a buyer's name. But again, it's important. This goes back to what we were saying earlier about making sure that you know who holds title to the property, because these persons may say, we own a property, we have this house, we've lived in this house for 20 years, getting divorced, we're selling the property, we will list it. You list the property, and then you find out that in fact, they don't even actually own the property. It is their trust that owns the property, and their daughter, who lives in Boston, is the trustee and is the person who's going to actually need to execute the closing paperwork. These are real scenarios that can be the case. And so that's why who holds title is really important. In our practice with Safer, we do a lot of work with trusts, estates. And so a lot of this is planning on the front end, planning for what happens in the event of a divorce. And a good way to do that is oftentimes with a trust. Somewhat related that I kind of wanted to touch a couple of points on is, we've been talking about how divorce affects title to real estate. But even in a case where parties are not divorced, actually the act of marriage itself can affect title to real estate. So for example, you've got a person that owns property and then they marry someone after the fact. Then once they're married, then there are dower and courtesy rights that attach by virtue of the marriage that can later be extinguished through divorce, but they exist at that time and they exist in a scenario. So let's say husband owns property and later marries wife, then husband dies, and maybe husband in his will made provisions for his children and a stipend for wife, but to take care of her, but not for the majority of his estate to go to the wife. Well, in fact, under Kentucky law, she has the right to renounce the will and say, I don't care what the will says. I want the amount that I would get if there was no will, which by default would essentially be half of the value of real estate. So in a scenario like that, the virtue, the fact of the marriage itself empowers that surviving spouse to really upend and undo the estate planning that perhaps husband has done by, instead of that property passing to the children, she can insist upon the sale of the property, the division of the property so that she can get her share, even if there was some other provision that was given to her under the will. If she likes the intestate share, if there is no will share more, she can renounce the will and take that instead. Now, there are a couple of ways that you can avoid that on the front end. One way would be through the obvious prenup or even a postnuptial agreement where the parties enter into an agreement that specifies that the wife is not going to exercise those rights, that she's not going to renounce the will, she can waive her right to renounce the will, etc. Another way would be through that trust planning. In other words, that is not going to attach to the property interest that is held by the trust. Their parties' rights as to the trust, or the beneficiary's rights, are going to be governed by the trust instrument itself. And because that decedent husband, the passing away husband, doesn't hold title to the real estate, but is instead a beneficiary of the trust, then her right to renounce the will and take half of his real estate would not extend so far as to claw any property back out of the trust. So these are scenarios that, we're not talking precisely about divorce in this context, but the marriage itself, there are marital rights that attach and that are dealt with through the marriage, the divorce, that require some intentional planning to make sure that the client's wishes, their desires, the things that they want to happen in the event of a marriage, a divorce, a death, etc. It requires that intentional planning to make sure that the deed says what the deed is supposed to say. If there's a prenuptial agreement, that it says what it needs to say. If there's some other arrangement, some other trust or estate plan that they want to adopt, that those instruments do in fact do precisely what the parties want them to do. And that's why we always advocate that somebody work with an attorney that they trust, that they have a good relationship with, somebody who knows what they're doing, and you can help make sure that their interests and their wishes are in fact protected. Because at the end of the day, with some limitations, it's their property, and they really can decide, jointly at least, they can decide what happens to that property. But oftentimes it requires them to do so a very specific way. And if they fail to do it that specific way, then even if they once upon a time agreed on the disposition of the property, it sometimes allows there to be a little too much room for someone to change their mind and insist upon and demand a different disposition of that property. I think that is, for the most part, kind of what we specifically wanted to talk about, and wanted to certainly, unless there's anything else Karen would add to anything I've said.
No, do we have any questions? Maybe I can't.
I do have a question.
Yeah.
So I have clients that the wife had a trust, had control of a trust, and her parent died, and that full control got passed to her. The husband and wife are still married, but they're potentially going through something. But they purchased the house with a down payment and mortgage together, both on deed, both on title. But she took that cash from her trust to pay off the mortgage. So then they go get divorced and he's put in substantial amount of money at this point anyways. How does that usually play out?
With complication. That's-
Yeah.
So what I think I hear you more or less describing is a question as to traceability. So she has inherited money or has non-marital assets that she's inherited or received from her parents, is what I'm guessing. And she can trace and show that that's where her investment and that has purchased part of the equity of the home. Then through the divorce proceedings, that should be reallocated to her as a non-marital asset. But it's the stuff of mediations and wranglings and hearings and subpoenas and discovery. And that's one of those hairy situations that the divorce lawyers are going to spend some time dealing with as to precisely how to define each party's title as to that real estate.
Mhm.
But it really comes down to that principle of traceability. And this is why the general rule is that when married couples commingle their money, when they dump it all into the same bank account, into the same purchase of real estate, that when they mix their dollars all together, then those dollars, by default, it is presumed that they lose any separate property treatment, that they lose the right to claim that as a separate non-marital asset. However, there are exceptions to that. And one of those exceptions is if the party that is asserting that an asset is non-marital, if they can demonstrate, because it's their job to do so, if they can demonstrate persuasively that they can trace that asset to a non-marital asset, whether it's a premarital asset, an inheritance, something like that, then they may be able to get that back, get that awarded to them through the divorce proceeding. But that's where that will play out, is in family court.
And so at what point is it safe for us to say, we're gonna list this house? What information do you need to have before doing that? Probably all of that done, right?
Not necessarily. I mean, if the parties, particularly if they are going through divorce and they have counsel, and if everybody agrees that the property can be listed, if they're both untitled, they both need to be listing the property. And then, it may be that they adopt an arrangement like Karen said, that they agree that the money, net proceeds are going to be held in escrow by one of the lawyers, and they can deal with that later on through the divorce proceeding. So as long as the people that hold title to the property are willing to sell the property, then where the dollars ultimately get allocated as between those parties, I don't see that as, it's hard for me to imagine where that really clouds the title. That's really between them. And I don't see a reason why not to list that property in that scenario.
And they could be in agreement even without the issue. They could be saying. So, but it doesn't sound like they're yet.
No.
He was just asking.
We were-
No questions right now that I've seen.
No questions. Okay.
We
Wait
don't-
just another moment. We don't belabor the point. I guess just wait another moment or
Yeah.
two.
Yeah,
I don't think I had.
We don't want to bore you guys, drag it out too much and, get too in depth on it, it is because, again, back to what we were saying at the beginning, it's such a specific thing and case by case basis on, how it's gonna play out, what it's gonna look like, and the scenarios are so different, but those are some sort of general ideas and points about, what y'all could potentially be up against and how to help, be helpful to navigate through those situations.
Did you cover death? Did you talk about that before? I think anybody died or?
Yeah, not in depth. We sort of briefly mentioned that in the context of, when someone passes away, or, how is the title held? Is it held by the parties as tenants in common? Is it with right of survivorship? We didn't really go into too much of that. It's a little beyond the scope of what we're doing. But if you have a specific question, you have to.
Well,
Now, close son where somebody did,
Yeah.
someone passed away and the son, it was intestate so well. And so then they just, we did go through the process where they had the judge approve the sale.
oh, good.
And then we were given a date, you know, you had to wait till
30 days, yes.
And so we just wrote that on the listing, because everybody was agreeing to take it off of it, and then we just put that in the listing, and we could not close before.
That's perfect. That is the, you know, best way to handle it. Sounds like you had your ducks in a row and you had, you know, your attorneys on it.
So that's what's so
Yeah.
important, is just making
Right.
sure when you start having that conversation with somebody who's just, oh, so they died, just skipped it, but to really
Yeah,
make sure that you kind of got all that.
Yeah, so that's a great point, because depending upon what the will says, even if they have a will, if they don't have a will, then you're likely gonna have that, that motion for leave for power to sell the real estate, have the court approve of it. And even if they have a will, the terms of the will are going to govern. And, you really need to work with whoever's representing them, you know, whoever that lawyer is representing the estate. If they don't have one, make sure they have a good lawyer. Because the scenario that you don't want to get into is different than the one you mentioned. You said the ducks were all in a row. Oftentimes the ducks are dispersed. And
They're saying,
Right.
it's our tendency to go, oh, the listing, I'll just do it, and you really want to make sure you
Right.
get that transference right over from power.
Absolutely.
My other example was, suicide, and so somebody inherited the home who lived out of state, but they did have a good, real estate attorney here, I guess a state attorney here that's helping them with some things. And I brought in somebody from the title just to kind
Yeah.
of let them know what their options
Yeah.
were based on what he was telling them.
yes.
And it just helped us make sure we could transfer the, sell it when it's
Yes.
time.
Yeah, it does bring up a good point. Let title attorneys step in, let, like, pass some of that along to us, you know, when you start getting into, you know, you need to contact the estate attorney and you need to talk, you know, contact title and everybody needs to be on the same page. If you got a good title attorney, you know, they're happy to take that over and take that out of your hands. And it's one less thing in such a difficult situation that you have to worry about, you know, let the attorneys make sure that they have, you know, the ducks in a row as much as they can be in a row and, you know, and play that out and make sure it's all done correctly, so you guys don't have to worry about it. We actually, you did mention briefly a case that we had, and so in this scenario, this is actually another good note to self. The husband died, and the deed just so happened to not be a joint tenants with a survivorship deed. Wife had no idea, so she just presumed that she had the right to list the property. She lists the property, and I think we were a little bit delayed on getting some information from the listing agent. We didn't even know husband was dead. There was no will filed. So we go to prepare for closing, and then it comes up that he's deceased. I think like you know, normally send out some forms and things like that, you know, for information. Comes up that he's deceased, and then I go to check the deeds since he's deceased, you know, it's not joint tenants or survivorship. So then actually brought Josh in to help work on the case. So they had 5 children together. One was a
I think it
minor.
was 30. I don't know. It was a little.
One was a minor. So then there was a garden ad litem appointed for the gardens. Yes, it took us, I think, we're finally getting that one close, but it took us 60 days to get it.
At least an extra 60
And,
days.
you know, they got the buyer, you know, agreed to, you know, hang in there and, you know, the poor lady, like, she had no idea, you know, she just, you know, so joint tenants, rather survivorship, you gotta make sure that's in your deed.
It's so important, and I did have an international client, he had young children, like younger than elementary age, they were all like under 6. And he wanted his home to be left to his children in the case of a death, he had a wife. So I put him into contact with our title person and to have that conversation, because it would have been the same thing, if it had gone to, you know, underage children, then they would have been assigned guardians,
Yeah.
they would become owners, and
Yeah.
it was so complicated. I wanted him to understand that he really needed it to be between
Yeah.
his wife.
Well, and that's a great, you can do that, but the right modality to do that is through a trust.
and you name the, you know, the trust that owns the property, the children are the beneficiaries, and wife or cousin or uncle or neighbor or somebody else can be the trustee to administer the trust on behalf of the beneficiaries. But that's a trust, an excellent situation where a trust can fit that need, whereas leaving it entitled to the children is a nightmare. And,
They were so young.
yeah.
So yeah, when sometimes when they ask those questions, you're just like, okay, I'm gonna talk to a little bit.
Yeah,
Tell you what you
Yeah.
really need to do.
Just think of us as members of your team. We're behind you, you know, happy to, you know, anything that you can, you know, whether it's us or anybody, you know, think of title attorneys, you know, state attorneys, especially in those situations, you know, part of the team.
That's a good segue to kind of maybe round out and just say, you know, one of the things that you can do at the outset is have a short list. You know, already have your short list of people that you think that you can reach out to when you've got a quick question. You got a question about title, you got a question about what somebody's death or marriage or divorce is going to do to that title. You know, have those professionals that are already in your phone, you already know who it is that you're going to call and say, hey, I got a quick question for you, because that's going to save you a whole lot of headache and ultimately save your clients a whole lot of money down the line.
That's all. Yeah.
Yep, I don't see any questions on here, so thank you all so much for your expertise and your presentation. It was really fantastic. I think there's a lot of great information on here. We had several more people jump online, so we'll get this posted to our YouTube channel. And yeah, just appreciate you guys showing up.
Of course,
A pleasure.
thank you, Paul.
Thank you.
Thank you.